So thanks again for having me. It's an honor for me to present my presentation on the paper that is about consumer protection, and it's titled Consumer Protection, the Case for Converging Regulation. And I know it's a bit unusual to talk about consumer protection at this conference, since as to my experience goes, this conference is aiming more to the classical type of regulation, which is a supply side regulation, while consumer protection more affects the demand side of markets. And however, I think that with the latest and recent developments in legislation in the European Union, we have to accept that consumer protection is emerging to be a strong and powerful tool for market intervention that not only has effects on the individual individual contract between the consumer and the trader, but also has huge effects on the market forces themselves. And one more opening thought is that this paper, I believe, if I may put it this way, will have an expiration date that is not so far away in the future, since it's discussing legislation that is currently under transposition in all European countries. So I very well think that if I wrote this paper 2 years from now or 3 years from now, maybe the consequences or the conclusions would be different than what we see now, because the legislation that I talk about, it's just shaping up both in Brussels, in the European Union, and in the member states as well. So with all those opening thoughts, my paper was aiming to discuss convergent regulatory issues in two converging markets, namely the telco market and the digital industry, if there is such a thing, market definition issues aside. And the way in which I constructed the paper is that first I walk through the regulatory framework of consumer protection within the European Union. Then I try to give a brief overview about the policy issues in the area of consumer protection. And then I applied the convergence, once again, this word, the convergence of these two thoughts into or over the telco and digital regulation, and I try to summarize the regulatory answers within two big legislations that are currently under transposition, based on the policy foundation of consumer protection. And I try to compare the regulatory intervention in the telco market and in the digital sector that is currently shaping up within the European Union. So first of all, in the beginning of the paper, I try to give a picture about how consumer protection regulation is currently structured within the European Union. And without going much into the history of consumer protection, of course, the development of consumer protection is within the European Union started later than the Union itself or the community itself. First, the ECJ, the European Court of Justice, was the groundbreaker on consumer protection issues, especially on the concept of the consumer. And only after that, the development of case law did the secondary law emerge. I think it's fair to say that the first decade of the 21st century saw a strong push in consumer protection because of the financial crisis, and that was aimed mostly at the financial sector and its adjacent sectors. And I guess we can say that the second and the third decades of the 21st century will see the strongest push in consumer protection in the digital sector. We see that now. We see that the European Union is constructing a regulatory framework whereby there are big horizontal legislative tools. These are the Unfair Contract Terms Directive, the Unfair Commercial Practices Directive, and the Directive on Consumer Rights. And then in each sector to which bigger consumer detriment is attributed, the sector-specific regulatory tools apply. And these, the two interesting regulatory tools from the perspective of my paper were the European Electronic Communications Code, the EECC, that is aimed at reshaping the regulatory framework of the telco industry, and the Directive 2019-770, which is the Directive on Digital Content and Services, which is only partially regulating the digital sector. Of course, the Digital Services Act is yet to come, so we'll see the full evolvement of the regulation of the digital sector from a consumer protection point of view only after the Digital Services Act is, well, first of all, drafted and then transposed, of course. Then I gave a brief overview about how policy basis or economic basis can be applied to the consumer protection regulatory framework. Of course, as I already mentioned, consumer protection is morely aiming at the demand side of markets. However, it's applying to the behavior of the supply side, of course, indirectly aiming at the demand side. I believe that we can say that on the demand side, there is emerging market failures as well. And I believe also that consumer protection regulation should aim at rectifying those market failures or minimizing the effects of those market failures. Of course, the paper didn't go into much detail on this issue, but all of that, all the market intervention based on consumer protection should rely on the concept of the consumer. Of course, there are different approaches to how a consumer behaves, whether you are a neoclassical economist or a behavioral economist, you think very differently on those issues, of course. All in all, I summarized 3 market failures that the paper aims to assess, and these are information asymmetry, so also the difference between knowledge with respect to a trader and the consumer, systematic failures in decision making. This is basically to the arena of behavioral economics, so how consumers, because of their cognitive failures, fail to bring optimal decisions even if they have full information. And the third phenomenon was lock-in or switching. So the phenomenon whereby the consumer doesn't switch or cannot switch from one trader to another because of different reasons. And the main thought of the paper was to analyze these 3 concepts and how these 3 concepts are handled within the telco regulation and the digital regulation. But first, I gave an overview of how, from the perspective of the EECC, the scope of these 2 markets kind of overlap. And so there is a new instrument that has been introduced by the EECC, which is the number-dependent interpersonal services, which is probably not the easiest definition ever made up by the European Union, but these refer to services like WhatsApp or Viber or Facebook Messenger. So all those services that don't use numbering resources, so don't use phone numbers basically, and connect people with each other. These services both are under the scope of the telco regulation and under the scope of the Digital Content and Services Directive. So I'm calling it DSD for the sake of clarity. And so if we go back to those 3 phenomena that were shown on the previous slide, we can nicely put together a comparison of how a telco service, a digital service, and an overlapping service is regulated under legislation currently being under transposition within the EU. So, so what it currently comes down to is that what we can see basically, or my assessment of what's included in these two directives is that information asymmetry is heavily regulated in the telco sector. So it's regulated by pre-contractual information measures, by contract summary obligation, and by other transparency measures obliging the telco companies to publish information on their websites. The digital sector is only regulated by the DSD, and of course we still have to see the Digital Services Act. But the digital service is only regulated by these measures with respect to these number-independent interpersonal services. However, the systematic errors in decision-making didn't make their way into the EECC, so there's no regulation based on. I could not find any regulation based on behavioral results in the EECC. However, of course, in the digital sector, there is regulation that is based on the thinking that consumers should be well aware that the rankings that they see while using, for example, search engines are based on something, and what those rankings are based upon. I think this is a behavioral economics approach-based, yes, regulatory tool, because we very well know that that ranking, even without the content of the ranked subject itself, can influence consumer decision making. And with respect to lock-in and switching, there is the so-called crown jewel, of course, the telco regulation from a consumer protection view. This unilateral modification provision, the contract modification, of course, is a heavily regulated process within the telco sector, and it both is in the digital sector. However, I detailed in the paper how these two unilateral modification provision sets differ a little bit within the telco sector and the digital sector. But as it seems, the regulator's thinking, or the regulator's mindset, was that lock-in and the possibility of switching should be made possible and should be made easy, both in the telco sector and the digital sector. And of course, within the telco sector, there is another powerful tool for minimizing the effects of lock-in and enable consumers to switch. That's the maximum duration of the contract. The new framework regulation still allows operators to enter into contracts up until 24 months. And of course, the porting regulation didn't become easier, but it became even more heavy on operators to ease the switching of consumers. So, so to finish up, I think, as I said in the beginning, this is kind of a midterm paper, because we will still have to see what kind of digital legislation the EU has in mind and how these legislative tools are transposed within each and every European country. So this paper probably will be evolving as the regulation evolves itself. And thank you for your attention.
Virág, thank you very much for your paper, which I have read with pleasure and I found interesting. As you noted, you thought that this conference is not really about consumer protection regulation, but about different type. And I myself am a scholar with a competition and regulatory background. So in fact, I think that we often consider consumer protection at this like long distance branch that we kind of do not, it's not that we do not care about, but we consider it secondary. And I think it is a mistake, because in the end, both competition and regulation ultimately care about consumers. And from this perspective, competition, regulation, and consumer protection all complement each other. So I think that we competition people should pay more attention to consumer protection. And from this perspective, I found your paper very useful. I also like, and I mentioned it at the very beginning, this division between supply side and demand side market failures, which seems obvious, but I think it's often not articulated in such an explicit manner. So it adds more analytical rigor, I think, to the discussion. So I really like that. And with respect to my comments, I will provide some comments both on the structure as well as content. These are, of course, it's like every author has his own vision or her own vision about the paper. So you may find some of them, of course, useful, which I hope you will. And others you may think, no, it doesn't resonate with me. So I hope I will be of help to you. When it comes to the relevance of the topic, I think it's obvious that in the years to come, both European Commission and many national competition regulatory and data protection authorities will pay loads of attention to the issue of consumer protection. This, I think, in a way is stating the obvious because everyone knows that. But what I think is useful is that when we start a paper, we should explain somehow, why do we care about this? Why have I chosen this particular topic, right? And when it's possible, some evidence is useful and informative. And there are many things you could use as an evidence. The one I have chosen is the European Commission's Consumer Market Scoreboard. The one from 2016 indicated that from all 29 markets that the Commission has analyzed, in fact, it was the telecom market that has demonstrated more problems than others, and where there were also significant differences between member states, which in fact supports the case for stronger maximum harmonization. Subsequent consumer market scoreboards have shown that situation might have improved a little bit in the telecoms, but in general, this is the problem where many consumers are highly dissatisfied. So I think this is a kind of anecdotal evidence that could be used at the beginning. With respect to the structure, I think that your paper has a very clear structure and is well balanced. For instance, you provide historical context in your discussion, which is useful, but it's very succinct. So you don't spend too much on that, but you provide useful information to the reader. Then some more critical comments about the structure. I think the structure, especially the first section, should provide three issues: the introduction, so the relevance of the topic, then the goal of the author, so what do you intend to achieve or demonstrate with the paper, and then a brief description of the structure, so how do you intend to arrive at the goal. And the goal of the paper is clearly stated on page 3. The paper will show how the layers of horizontal consumer protection and sector-specific consumer protection measures complement each other to create a converging regulation for the converging telco and digital industries. It's a very clear goal, but it's only on page 3, and it should have come from me in the outline of the paper. Then a suggestion that I don't know whether will resonate with you is a potential different way of structuring section 4. So section 4 focuses on emergence and convergence, the sophisticated interplay between the telco and the digital sectors. And then there are two subsections, one on the telecom sector and the other one on the digital sector. And within each, you discuss information on asymmetry and systemic errors in the decision-making and then switching. I was asking myself whether it would have been more useful not to have the telecom and digital divided, but rather have this information asymmetry and switching discussed both together so you can compare them. And in particular, I think when it comes to switching poses very different issues in telecom and the digital, and it's also linked to the nature of the contracts, because usually we have this 24 months contracts in telecom because the telco operators subsidize sometimes the handset, so we have to pay it back. In the digital, it doesn't happen. You don't have to pay back anything, right? So hence there is no generally we don't have this long contracts, but then again, digital sector is also very wide. I will get back to that later. So this is on the, I think on the structure, that's everything. Yes. So what may be missing in the paper? From my perspective, I like to ask myself, is there anything that should have been there? So given that we have just said, you in the analytical part, you have focused on information asymmetry and switching, maybe it could have been useful to mention somewhere at the beginning, introduction maybe, the typical type of problems that arise in the digital and telecom sector on with respect to the demand side. From various documents, we see that most common issues are access to information, transparency, quality of service, equity or right of access to services, personal data, privacy, confidentiality of information, and the right to complain. So what could have been done is to mention these issues at the beginning and then explain why you have chosen to focus particularly on information asymmetry and switching. Then a big question mark for me is the privacy, because it's something that is cross-sectoral, is of importance, of course, in digital economy in general, but is of particular relevance for the telecom operators and for the digital platforms or people active, entities and market players active on the digital sector, because of their ability to extract so much personal information. Then on top of this, if we look at the GDPR, it mentions consumer protection explicitly only once, whereas the European Commission's proposal from 2012 on consumer agenda mentioned privacy only in passing. But we all know, and it's been said many times very clearly, including by the European Data Protection Supervisor, that consumer protection has a part to play in the privacy protection, and especially on the issue of transparency. And just let me have a, okay. And in this particular aspect, one could consider two features of EU consumer protection law: the scope of the fairness criterion and opportunities for participation. How many minutes do I have left?
None, but go on.
Okay, okay, I'm almost done. Then some potential improvement. I like, and it's a personal choice, when there is analytical kind of, especially if we have a comparative paper, no? So we look at telco and digital, to have an analytical comparison. What are the similarities, horizontal, and what are the differences, and whether this is also reflected in the regulatory responses. Then I was asking myself, your paper seems to be about consumer protection in telco and digital, but could you actually narrow it down and focus on the impact on behavioral economics on the convergence of these two issues? Because I think this behavioral economics is something that really goes throughout your paper, but it's not explicitly mentioned. You seem to be a little bit timid about saying it's really, what I want to say is how behavioral economics has changed those things. Okay, and the last comment here is that, as I said, the digital sector is very wide, no? So you can simply refer to buying online, or you can refer to specific problems posed by the big digital platforms. This could have also gone to the analytical part, explaining kind of particular problems posed by the digital sectors. Both Matthias Finger and Juan Jose Montero have this concept of digital platforms as super intermediaries that have an impact on traditional telecom and traditional network industries, and how they have changed the relationship between those traditional network industries and the end user. And I think this will also have an impact on the consumer protection. So this distinction could also come there. The big question, of course, then would be liability. And then when we come to the issue of redress or compensation or any kind of problems, it's much easier to go against the national incumbent, as much as it may be annoying, because it's national, no? So we have a national body and so on. But when it's a digital platform, a big one, it's like, where do I go as a consumer? Many people wouldn't even know. So it's also the question of awareness. On my last slide, I have included some papers, some sources that I think could be useful. One that is maybe less relevant, but maybe you could find something there. Colombia has undergone in 2016 an overview of its consumer protection in the telecom sector with the support of the OECD, in particular based on the insights from behavioral economics. So maybe you would want to look into that. Thank you so much, and I hope my comments have been
okay. Thank you, Anna. And I have two more questions that I just add there, and then Virág, you can answer. But one from Günther: do you think what do you think is the changing role of consumer protection in the future of big data-driven IoT? You know, the whole IoT. And then Juan, about data portability in GDPR. You know. So as an anti-lock-in rule, you know. So can you say something about that? Okay, so please go ahead.
Yes, thank you. So Anna, thank you so much for your very useful insights. I was trying to make notes while you were summarizing your comments, and I would like to structure your comments and just come back to them in a structured way, and also to Matthias's comments. So I fully agree with you that the paper could be developed in many ways, and one of the reasons for this is that I truly believe that we are just facing the things to come right now. I mean, the role of consumer protection, and that already comes back to the last question, is just shaping up as we speak in the era of online platforms as gatekeepers versus telco operators, and so on and so on. So what I think my vision is about this, that data protection, competition, and consumer protection, all three of those regulatory areas will play and interplay with each other and kind of create this regulatory framework. And you're totally true that yes, data protection is an extension of this paper with respect to the GDPR and the e-privacy directive that applies to the telco sector. And of course, competition issues should be involved as well if we wanted to give a full and broad picture about how the evolved telco and digital sector, whatever its name will be, or however it will look like in the next 10 years, it will be regulated, I believe, with these three tools, and sometimes these three tools playing with each other. So if you think at the Bundeskartellamt case against Facebook, that is bringing, Bundeskartellamt has brought an antitrust case against Facebook that had deep roots in data protection. The Hungarian Competition Agency, from where I'm from in Hungary, is bringing cases against Booking and Facebook because of the depiction of their free services. And so, yes, I fully agree with both of you that these three tools will be and should be taken into consideration together. The paper is a puzzle in this, and I truly believe that yes, this should be included in it. If I included all those two areas, I believe that the paper would have been like 50 pages long. It could have been done in this concise way. And also coming back to your comment on behavioral economics. Yes, I am a big fan of behavioral economics, and I very much believe that behavioral economics should be taken into consideration in policy making. The reason why behavioral economics doesn't play a bigger role in the paper is that actually when you look through the EECC, the telco regulation, you have to conclude that it's based on information economics, basically. Or mostly, I would like to say, of course, not saying 100% things or for sure things. Being a lawyer, I could never say that. But so most of the regulation, I believe, is based on not behavioral economics, but information economics. However, you're totally right with your comment that could be explored more, how or the reasons of this this phenomenon. And that I think is a very fair comment, and I will work on the paper in that regard. And with regards to this big data and portability issue, I think that yes, I think that comes back to this thinking, and I'm just smiling because so many thoughts just flying around right now on this issue. So if we come back to the title of this conference, the regulation of infrastructure. So if you look at this, and I know that this conference has talked about this before, if you think about these online platforms as owning infrastructure being the data, then of course consumer protection, as the Consumer Protection New Deal is intending, should be focusing on services, I believe, whereby the operators or the traders say that their services are free. However, you are paying with your personal data for the service that you consume. And that's something that you can see with this Facebook case. And that's something that is included in the Omnibus Directive that is modifying the Unfair Commercial Practices Directive to make it explicit how the concept of a free service should be depicted from a strictly consumer protection view. And the portability issue is coming back within the EECC when portability is actually, the concept of portability is broadened to these interpersonal number independent services as well. So under the EECC, you should be able to port, for example, your email, which it is a little hard to imagine, but still you would have to do that. So.
Okay, thank you very much. Just to conclude, maybe, to add one more question to you, and it's rather a thought, you talk about convergence. It's not even your fault. I think it's the Commission. You talk about convergence, but the way Juan and I conceptualize it, it's not convergence. You have a telecom and then you put a platform on top of it, so you're sort of, you can still look at consumer protection and what they have in common or not, but it's not that, like gas and electricity merging together. It's something that sort of platforms something else. It's a little bit of philosophical thought, but that.
Or for me, working at a telco company, this is more of a technological issue, like platforms who are using the bit stream of a telco operator. Yes, but what I think is that yes, but there is more and more telco operators trying to go into these OTT or platform arena, and more platforms that are using services or offering services like Amazon that actually are the competitors of classical telco services. So from a technological point of view, I fully agree, and from even a philosophical point of view, but from a competition point of view, if I can come back to Anna's perspective of being brought up in the competition arena, it's these services are, I would not dare to say, of course, because Commission hasn't said it, that these are on the same markets, but from a consumer point of view, I think there are very strong arguments that these are substitutable services, and that's why I think that's how I think about convergence.
Sure. No, but it's worth a discussion. But Anna, and then we conclude.
I actually, since you mentioned convergence, I will build up on that because that was also something I have asked myself. For me, convergence, when I think about telecoms, means about using one platform for offering different types of services, and also convergence of IT, telecom, media, and so on. But that means using one thing to deliver different things. When I think about regulation and convergence, I think what you mean is more that regulation of those areas becomes similar, no? And in some aspects, it's one instrument that is cross-sectoral horizontal. In others, it's separate instruments, but similar in nature, no? And maybe from this perspective, given that many people who work in telecoms, when they hear convergence, they would think of this technological convergence, maybe explanation of convergence in terms of regulation could also be useful.
Policy learning. Yeah. Political scientists would call this policy learning.
Yeah. Yes.